You have my profile.
Yes, ma'am, I have, and we are live, ma'am. So, a warm, happy afternoon to all the participants who are joining with us for this webinar. Like, this is our 20th webinar of the Law Gardener, and I am Nirmal Kumar Jain, a law student and the founder of Law Gardener. On behalf of our team, I would like to welcome Advocate Juhi Arora, ma'am, for this 20th webinar of Law Gardener on the topic of rights of women in family property. Ma'am were the first guest of our first webinar on false domestic violence case, and now they are on for the 20th webinar, and I'm sure this webinar will be helping the women to know about their rights in the better way. It will help the students and lawyers in the academic and practicing career also. Before we start the webinar, I would like to give you a brief introduction of our guest. Advocate Juhi Arora is the founder of Juhi Arora and Associates, and is currently a panel counsel of Delhi High Court Legal Service Committee at Delhi High Court, and ma'am is also a trained mediator by DDRS NCT of Delhi. Ma'am is one of the member in the advisory board of Loyal Law College GR Noida. Ma'am is also one of the employer at Corporate Resource Center Group of Amity Law School, Noida. Ma'am is also the legal panelist in Ethical Committee of Genstring Diagnostic Center. Currently, first diagnostic center at the airport for COVID testing. Further, many judgments and orders of ma'am have been reported in DLT and various other leading newspapers. Ma'am has been regularly giving free lectures in webinars and sharing her knowledge among students, and more than 1,000 students from various law colleges like Amity, Symbiosis, Loyal University have interned under the ma'am down the line. Ma'am has also been awarded with National Women's Excellence Award India 2020 on the Women's Day. Also been awarded in the and in the list of 101 influential women 2020. Ma'am has also judged various events law of the law colleges and bar court association. We are very grateful to have you as a speaker for us now, ma'am. And now I request you to take the session further, ma'am.
Thank you, Sudhanshu. Thank you for allowing me and asking me to come here and speak on some of the very good topics which are very much necessary. However, we are in the middle of the court's time. I know it is difficult for everyone to attend this, and it is little difficult for me also in the middle of the hour to speak on this topic. But still, because I have already committed to Law Gardener and I always abide my commitment, so I'm here. So basically, the topic of today is like rights of women in the family property. Rights of women in what sense? Like, do we need to talk about the women who are mothers, or the daughters, or the wives? We'll talk about everyone here because woman is something who is carrying several duties. Woman is can be a daughter, woman can be a wife, woman can be a mother also. So, what perspective we have if we talk about the rights of women in sectors and different parameters? So, as far as the first, we'll talk about the daughters, which is the foremost topic. That what are the rights of the daughter in the property, in the family property, in the father's property, or in the joint family property? Basically, uh, if we talk about the Act of Hindu Succession Act, Succession Act was the enactment wherein we talk about the succession and we talk about the successorship and all the legal heirs, what are their rights, what are their um, complications, how they have, what is basically law tells about in that in Indian Succession Acts is all which roam around the succession of the family, joint family, which devolves around the son. Earlier, it used to be like this. But however, in 2005, there is an amendment in the Act which clearly states that now after 2005 amendment, which really came up like a tsunami, and which was an eye opener. और कहते हैं ना कि mirror breaking law which has happened and which really gave the rights of the daughters in the joint family property. And these in this amendment, it clearly comes up with a safeguard to all the women who are daughters and who earlier used not to be have any right in the property of the father. Like I would say, अ, अगर ये कहा जाता था या पहले से ये चला जाता था कि कोई भी अगर जमीन या कोई भी चीज का बंटवारा अगर है तो सिर्फ मेल मेंबर्स ऑफ द फैमिली दैट कॉल्ड टू बी सन इनके बीच में ही बंटवारा होता था. बट आफ्टर दिस 2005 एक्ट, in our amendment in the said succession act, daughters have been given full rights which are equal to the son, and it is not by the virtue of the daughter, it is by the virtue of their birth. So that is the something which really had made a woman empowerment and also give the gender equality to the same, that now daughters who are the women in nature will also have the equal right as to the son who are men in nature. So now they will have equal rights towards the property of the father. बट इसमें भी ना कुछ एक राइडर था जो कि ये कहता था कि अगर कोई भी प्रॉपर्टी 20 दिसंबर 2004 से पहले अगर पार्टीशन नहीं हुई है तो ही आप जो है उसको यू कैन आस्क फॉर अ सूट फॉर पार्टीशन, और यू कैन इफ द फादर इज नॉट अलाइव और फादर इज अलाइव टिल 2005 सितंबर तो ही आप जो है पार्टीशन जो है कर सकते हैं. अब इस राइडर की वजह से देयर वाज लिटिल स्केप्टिकल, सम केसेस वर बीन फाइल्ड आफ्टर जहाँ पे पार्टीशन नहीं हुआ है और फादर अलाइव है, और जो है आपका 2005 के अमेंडमेंट की बात. बट यू नो in 2020 the other judgment come which was a apex court judgment, and it was again and again uh, more and more स्पेसिफिकेशंस करी गई, क्लैरिफिकेशंस करी गई जजमेंट में. और सुप्रीम कोर्ट की जजमेंट जो डबल बेंच की जजमेंट थी आपकी जस्टिस अब्दुल नजीर और कृष्णा मुरारी जी की, जो कि ये कहता है कि राइट ऑफ अ वुमेन या फिर जो वुमेन्स राइट है टू दी interstate property of the father, which is before even 56. So this was a judgment which actually opened the gates of the, and it have bring the floods of litigation also, I could say, because here and now, even if the father is not alive or even the property is not partitioned before the 56 enactment of the act also, you are liable and you are eligible to get your share under the property succession act, and you can go for a suit for partition. And now people would ask me, why suit for partition only? Because see, you need to go for a basically you need to ask for your share, and your share can be asked only by the virtue of a petition or a suit. You need to file it before the concerned court, and concerned court will give you your share only when you will have a uh, definite movement of a petition or a suit, we would say, under the provisions of the law. So you have to go for a suit for partition, where anybody who is suffering from any kind of injustice from the hands of the family, wherein the father is died intestate, specifically the father is died intestate. So this act only covers to those person who is died intestate. It means that the father has not died without, has died without will. So this is the basically concern, because if somebody has died with the will, it itself it comes to a conclusion that the property will devolve accordingly the will. How the will is giving the correct correct conditions that it will be devolved to which person or to not, to which legal heir and to not, it totally depends upon the person who the property is. So in case if somebody is died without will, which is called in our legal terms intestate, can easily access the suit for partition if the partition is not being done and it is not getting a good share, especially women are not getting the share. There was a case wherein one of my client approached me with the wife, stating that the brothers are not giving good share to the sister. However, the father died intestate. So we moved a application, we moved a suit for partition with an application of 3912, which says the injunction needs to be granted before the defendants that are called so-called brothers will not alienate the said property or mortgage or lease out, or not to create any third party right in trust. So for that purpose, we have filed a suit for partition, and the matter was taken up by the court. the relief was granted, then it was taken to a mediation, and however, at the end of the day, the matter was settled between the brothers and the sisters. So now, by no choice, the brothers has to give share to the sisters, so they had given that. So this is the kind of a power we have in our law and in our judiciary, that if you are being getting injustice or you have been starved for your rights, so you should go for a kind of a suit for partition, wherein you can seek your share in the interstate property. So now this was one case, but then what if you are not a daughter and you are a wife? So will you not be having any share in the joint family property of your husband? Of course, you will have the share in the joint family property of your husband, but you can only have the property share only if your husband is not alive. So this is the rider in here when we are talking about the rights of the wife, women who are wives. That in case if you are uh, a widow and you have a joint family property wherein your husband has a full share, so to that aspect the share of your husband will devolve around you, will devolve upon you, and you being a legal heir will have the right in the joint family property which your husband used to have. So this was one case, and then there is the other case which we talk about, that what if that if the woman who is a daughter who is seeking his right from the father, but he is sorry, she is not likely to maintain any relationships with the father. So will that really be good enough at the hands of the daughter? So no, there is a judgment of a Karnataka High Court which says that sorry, it is a judgment of a Supreme Court and it is not a 100% judgment by the apex court, which clearly says that if a daughter does not want to maintain or does not want to have a good or cordial relationship with the father, then she should not be maintained also. See, there are judgments which are pro and which are against. It's just that which suits your case, you need to find that. Because I believe that everything which is under the sun has a meaning to it and has a judgment towards your case, whether you stand for the woman or whether you stand against the woman. So that is my concern. And secondly, there is also a judgment by the Karnataka High Court which says that the property given as a dowry to be included in the suit for partition. It is a very good judgment which just came in a month back or so by Justice Govind Raj, which says that in case if the woman has already been given a property as a dowry, will that property will also be included when we talk about the suit for partition for the whole family? Yes, you have to include that suit, and it can be included. It can be included. Of course, the merit of the facts or the cases depends upon totally depend upon each to individually. Just because you have a precedent, it will not follow on all the cases. I would again say whatever I am discussing here, in large, it is in general, it is in totality. It is not only to any particular case which I'm talking about, or to any particular thing you can talk about. It is in totality I'm talking, and any precedent which matches your particular facts of the case, general information which I'm trying to provide to the viewers or the listeners, so that they should be aware that you have that rights first of all. Secondly, it totally advisable to always have your problems first of all get it rectified or get it advised by a proper professional, so that whether your cases match that precedent or not, that will only be advised by a proper professional to you. And as far as the students are concerned who are listening, or the young comers or advocates are concerned, so it's totally up to you how creative your mind can be. And because law permits you now, law permits you, you can advise your clients accordingly, that you have the option to approach the court for the suit for partition in case if you are coming across somebody who is being given injustice to their as per the share in the joint family property. Because I have talked about the daughters. Now daughters have the full right by birth, in fact, now. Being the one of now they are given a co-partner right. Then we talk about the wives, then wives, the as far as the rights of the husband are concerned, the wife would have the right only with related to the right of the husband with respect to their right. In case if the husband is not alive, wife would have the definite right in the joint family property, which is of the husband, and now it will devolve upon the wife only. There was a case which we have filed by the widow daughter-in-law against the father-in-law in the court of Noida, and there also we have filed a suit for partition. And so you have that all the opportunity or the options to go in the court where you can ask for your share. The point is that you should be very much well aware that whether law permits you or not, your husband being alive, can you still ask for a share? A woman can ask for a share in a joint family property against the husband? No, you cannot. So it totally depends, but what is really been permitted by the law. So you have to talk only about it, and then you have to advise accordingly. So as far as the daughters is concerned, daughters have the full right, wife have the right only with respect to the right husband who is not alive. And as far as the daughters are concerned, so I've already spoken about it that daughters have the full right in the property of the joint family property. Now it's only in the joint family property. When we talk about the property, there was a judgment which just came 3 days back by the Bombay High Court that the son will have no right in the father's flat who is cell phone. So this is very neutral, and this is very generous that in anybody who is cell phone property cannot be divided if it is uh, not interstate. If somebody who dies interstate is called to be a joint family property, and then it can be divided accordingly. But if the case is so that the father has left a will, and then the properties will be divided accordingly and as per the wishes of the deceased, which is written in the said will. That is must to be understand that basically you have to choose the whether the said person has died interstate or not. So जिसकी प्रॉपर्टी का डिवीजन आप चाह रहे हैं वो इंटरस्टेट थे कि नहीं, ये तो पहले बहुत मैटर करना जरूरी है. There was a case where we have filed by the sisters against the brother. There was another case wherein the uh, brothers have settled the dispute before the case was filed by the only at the hands of legal notice. But then, due to unfortunately, the wife died, the sister died. So now we have filed a case on behalf of the husband, that is called the son-in-law, the division of the father-in-law property, and by the son-in-law as a legal heir of a sister. It means that if a sister is not right now alive, so just because she is not alive, his legal heir, her legal heirs, like the husband and the children, will not have the right to have a share in the grandfather's property, maternal grandfather's property. Yes, they have. So that's what we have done. We filed a suit for partition, wherein the sister, it was eventually against the brothers by the sister in the to ask for a share in the property of the father, but later on it got converted as a suit for partition filed by the legal heirs of that sister, that is the husband and the children, against the uh, brothers of that deceased sister. So So this is the way that you need to first understand that if somebody who has died intestate without the will, you have the option to explore the Pandora box, and you can open that and you can seek a good relief from the court. And secondly, you can ask a relief even if you are in a nature of a woman, a daughter, or a wife, only depends upon that basically you should have that law permits you to ask for that relief. And now, after this amendment and the recent judgments of the Supreme Court, court has given full authority, I would say full power, to ask for your rights and to ask for your share in the joint family property. And there can be a no case where you can be asked to sit quiet or not ask for your share. So it is just that you need to approach the right forum. And when we talk about the rights of the daughter in the joint family property or the rights of the woman in the joint family property, as I started the the webinar, and I said that कि जो rights हैं जो women के हैं वो बहुत तरीके से decide करे जा सकते हैं, क्योंकि woman जो है daughter भी है, woman जो है wife भी है, woman जो है आपका sisters भी हैं, तो आप basically क्या concern रख रहे हैं ये matter करता है. So up because the father is not alive, only first of all there are some riders we need to accept that this is the case where the father is not alive. For number one, where the father has died intestate, that is also important because had there been any will, so you will not be able to contest this one for partition. But is there no way around that you will not have any chance of getting the suit for partition filed even if you have come to know that the will is there? So the point is that no, you have opportunity of challenging will. You have an opportunity of challenging that will. You can easily challenge the will. So once the will is challenged, you can ask for a suit for partition also. You can seek a declaration to get that will null and void, to get then cancel of that. It totally depends that the will is further been registered or not. The on the other party, which on which the other party is relying upon, whether it is a registered will or it is not a registered will, whether it is probated or not. So there are so many parameters which need to be discussed, and it's a very lengthy topic. See, it totally depends that what kind of case you are studying and how you have to cover up all the points, and you need to strategize your case. You need to research it on lightly. It's not the case. It's not a straight. There is no straight jacket formula for every case where you fit in. You need to first calculate your mind. You need to see that whether all the parameters fit for your case for filing any suit for partition, because it's a civil case. You need to understand each and every parameters. Only then you would be benefited and you would can expect for a good result. So I believe that you need to first see all the riders, whether it is uh, covering all your major points, and then only you should go ahead with the filing of any suit for partition. As I told you, there is a judgment which says that if it comes to a right of a daughter in the joint family property when the father is alive. So if the father is alive, then the right of the daughter would not be devolved till the time the father is alive. So you will not have any right till the father is alive, and it's totally depend upon the father that whether he now wants to devolve this property to the children or not. It's totally at the hands of the father. So now the point is that if the father is not alive, we have already discussed about it. Now, if the father is alive, what are your rights? Your rights to that aspect will also, I told you that you will have only right to maintain. You can ask for a maintenance, you can ask for your survival from the father, seeking the petitions for maintenance under 125, and so that you can ask for a maintenance or adoptions act. So you can seek the maintenance when your father is alive. You cannot ask for a share in the property for sure. And if it is a self-acquired property, then in any case, it is a big no. And I would say there's no chances of asking for any share in the property where the property is self-acquired and the father is still alive. So this is the case wherein you need to understand that first of all, we need to prioritize that what kind of a case we have got and how we have to deal with it, whether it is falling into a section of an interstate or whether it is falling to a section of a without interstate. whether the father is alive or whether the father is not alive, whether it can be fit for a share partition or whether it is only for maintenance. So we need to seek all the parameters. It totally depends upon merits of the facts, totally depends upon the facts of the cases, and then only the guidance needs to be done. So I guess because it's a very lengthy topic and it totally depends that how now I have been put up the questions. I would like your audience to ask questions so that I would answer, and might be I could be able to answer much more points which are there in the questions which I am not able to cover here. Because at times when we read a question, we come to know that something is left out. So I can cover up those points in the questions.
Yes, ma'am. So we have questions like there's a person has asked if will can be changed if registered or not. Short
Will
question.
can be challenged. Trust me. And there is a case which is right now pending in the Delhi High Court, wherein we have challenged a will and we have sought a suit for partition and we have sought a relief of injunction and we have been granted. And the other day, in that particular case only, I was standing and in the contempt petition, we have got a relief wherein my client has got then access to a terrace also of the suit property. So it's not the case that if you have got to know that somebody has got a registered will if you feel that is a fake will, so your case is down and there is no nothing to do now. You have always have a chance to take. You can register. You can ask for a cancellation of that will. You can challenge that will, but everything has to be in under the limitations. See, we have 3 years of limitations. So has to be done under the limitation period of 3 years. It's not that you are aware of the will and you are going to challenge that will after 10 years or so or 5 years. So nothing, ignorance of law is not at all a reason. So you need to be very much aware if you know that somebody uh, on which you are claiming your share has relied upon the will. So you need to challenge that will if you really feel that that will is something which has been hidden from you or it is not a right will. So you have always chance to go and challenge that will, and on that basis you can seek for a suit for partition.
Yes, ma'am. So like the same person has asked about what about self-acquired property of father?
I have explained it very briefly
Yeah.
and categorically in the session that if there is a self-acquired property of a father and the father is alive, so there is a big no. See, मेरी जमीन मैं किसी को भी दूं, it's that the case. It's my property. I can beg. I can give to a charity. I can give to a. I can give to anybody. It's totally my decision. So it's the case wherein you cannot ask somebody to say that कि आप अभी जिंदा हैं आपकी प्रॉपर्टी थी क्योंकि मैं आपका बेटा हूँ as per biological son, so I would be the only one who should get this property. No, there is a judgment of Bombay High Court just a week back. Maybe not even week भी नहीं हुआ होगा. अखबारों में आ रहा है. It is a very beautiful judgment which says that son cannot claim any share in the flat of a father of a self-acquired property. So it's totally his choice. And there are judgments which categorically stated that women or the daughters, even who is seeking for a so-called rights as per the Succession Amendment Act, so they have to maintain their father also in the old age. It's not the case that you can only ask for your share. You have to maintain your old age parents also. So if स्पेसिफिकली ये जजमेंट आया था कि जहाँ पे डॉटर्स जो हैं अपने राइट के लिए केसेस फाइल कर देती हैं, लेकिन फिर वहां पे जब मेंटेन करने की बात आती है ओल्ड एज पेरेंट्स को, देन दे डोंट डू बिकॉज दे आर डॉटर्स देन. So no, because you're a daughter, you have a right to share in the property. So you are being a daughter, you also have a right and liability for your parents.
Yes, ma'am. Like as rights and duties goes together. If you want a right, then
Yes,
you have to follow the duties too. So,
correct.
yeah. So, like next question, ma'am. How rights of inheritance of the over the ancestral and self-acquired property after the 2005 amendment change, ma'am, difference.
Difference is that it has opened the Pandora box and flooded with the good amount of litigations. The woman has been given more power. Daughters are now equal to the sons. So this is a gender equality we are raising, and कहते हैं ना एक युग बदल रहा है, एक अलग ही तरह का संचार हुआ है इस दुनिया में जहाँ पे हम इक्वालिटी की बात कर रहे हैं, तो हमें इक्वालिटी दिखानी पड़ती है, सिर्फ बोलने से इक्वालिटी नहीं आती है. And by passing all these kinds of amendments, by doing all these kinds of judgments, we can feel that there is a now we era where women are treated as equal as men. So the thing is not changed. It's just that the litigation is now more and more, and now, और I think इस right की वजह से आई थिंक मेन आर अवेयर नाउ, बिकॉज ये बहुत तरह से न्यूज़पेपर्स में आया है कि कोई अगर कोई भी लॉ अमेंड होता है तो उसको बहुत तरीके से बताया जाता है और बहुत ही तरीके से इस चीज को एक्सप्लोर करा जाता है कि लोगों को पता चले कि इस तरह का राइट है, और वहां पे हम कोर्ट की लिटिगेशन जाने से बेटर है कि हम इस चीज को पहले ही समझ लें कि अब लड़कियों का भी हिस्सा है. तो जो अपनी मर्जी से हिस्सा छोड़ना चाहती हैं उनके लिए एक सेपरेट इशू है, और जो नहीं छोड़ना चाहती आप उनको फोर्स नहीं कर सकते. सो इट्स बेटर कि जो है आप उनको उनका शेयर दें, एक बैठ के जॉइंट फैमिली सेटलमेंट करें, और अगर वो चीज पॉसिबल नहीं है तो ऑफ कोर्स शी हैज द फुल राइट टू गो इन द कोर्ट ऑफ लॉ.
Yes, yes, ma'am. So, ma'am, how does succession law varies in different religion, ma'am? Like, what are the variations we can see?
देखिए, दिस इज ऑब्वियसली हिंदू सक्सेशन लॉ, and basically now it's a Hindu succession act. So I was categorically talking about the Hindu religion. As far as the Muslim religion is concerned, देखिए हर religion का अपना एक अलग तरह का segment है, because we do not form a uniform civil code. That's our the ugly truth right now. But that's the truth. Every religion है, उसके लिए हमें एक अलग सेशन रखना पड़ेगा आई थिंक, क्योंकि हर रिलीजन का क्या है, स्पेशल मैरिज एक्ट में क्या जाता है, स्पेशल एक्ट में क्या जाता है, या मुस्लिम एक्ट में क्या जाता है. इट इज अ वेरी लॉन्ग प्रोसेस टू अंडरस्टैंड, एंड अ वेरी लेंदी डिबेट सेक्शन जहाँ पे हम बात कर सकते हैं कि ऐसा हिंदू में है तो वुमेन्स में क्या है. क्योंकि वुमेन में देखिए मेंटेनेंस है, वहां पे अगर हम डिवोर्स जब लेते हैं मेहर की बात करते हैं, यहाँ पे हम एलिमनी की बात करते हैं, वहां में मेहर पहले डिसाइड हो जाता है, यहाँ कुछ भी पहले डिसाइड नहीं होता. So totally every religion follow their own statute, and because we are not having any uniform civil code, so we have to follow that accordingly. The other day I was standing in the court of family courts, wherein the court has किसी पता नहीं किस केस में किसी मुस्लिम लिटिगेंट ने केस में फाइल किया, तो जज साहब ने यही बोला कि आप मुझे एक प्रेसिडेंट ला के दिखाओ कि आप बीइंग अ मुस्लिम कैंडिडेट litigant you can file a case in this particular act. See, you have to go according to act. As I said, that do something which is permitted by law, then you don't worry about what would be the repercussions. Let it be. Whether you एक ही चीज दो ही चीज होगी, या तो आप केस हारोगे या केस जीतोगे, वो एक एंड स्टेज है. बट एटलीस्ट लॉ परमिट्स यू ना, you should take a
Yes,
try.
ma'am.
That's the only funda.
Trial and error. Try करते रहो,
Yeah.
हो जाएगा.
Correct.
So yeah, ma'am. And okay, there are no more questions, I think, ma'am. So, ma'am, is there any like can you tell about some major judgments from the Supreme Court about relating to this women's right in the property, ma'am?
I have, during the sessions, I have quoted some judgments, and I would rather give you the name of the judgment, and then you can upload it at your website. Because again and
Yeah.
again, it will be difficult right now. Which
Yes,
I
yes.
have quoted, I would, there are three, four judgments on which I will categorically give you, and then you can upload it at your website.
Sure, ma'am. Sure. So, so there are no more questions, ma'am, I think. Yeah. So like I think we have to conclude the session. Like there is no more question. But yeah, before concluding the session, ma'am, in general, can you give some advices to the as a law student or the budding lawyers? How can they develop and how can they grow in this legal profession, ma'am?
See, for this, I would always say whenever my video come, or whenever I'm at any platform where I can address, where I'm addressing the law students, and वो उसमें मैं वही कहती हूँ कि because I have followed a footpath for 4 P's. So I think the newcomers should also follow the footpath of 4 P's. And that what are that 4 P's is like, first P is like uh, passion, that you should have a passion towards this profession. So please create your passion inside you. Then the second is the patience. You have to keep patience, because if you have passion but you don't have patience, you'll go back to the you'll be back to your pavilion, because you will
Yes.
not be have a patience to go ahead with the, because there are lots of ups and downs in this profession when you see, and it's a challenging field. It's not like any Tom Dick Harry can do a law and can go and practice. Maybe you can do law but you cannot practice. Then the second P is patience, and the third P is present. That's called knowledge. So if you have patience, you have passion, but you have not knowledge, you are not updated, you do not know what to be done in the case, what should be the new strategy, how to go ahead, what your provisions allow you, you cannot get a relief to your client. So please follow these 3 P's. And the last P, which I believe is also the one of the most important P, is called presentation. So you should have a presentation skills of drafting your how to present your case in the court, because you would be submitting a 50 pages, 100 pages petition. But actually that 100 pages petitions has to be read every time before the court. Only few points needs to be presented before the court which are actually necessarily at that time. So presentation skills are required when you're presenting your case, when you're drafting, when you are doing cross examinations. Even if you what you are wearing, at least that presentation is also, I believe, it's most important, that how you're presenting, how your body language is presenting. So all the 4 P's are much must necessary. Just follow like a thumb rule. I believed in so, and that is why I think we are getting success. And this profession is a never-ending process profession, and we are learning till the last breath of our life. And
Yes.
if you can see today also, I'm in the middle of the High Court date, which is about to start at 4, and with the Law Gardener webinar. It's because my passion to, at times, I am also jumbled up between the charity and the and the profession. But any which
Yes.
ways, I'm happy that if something can be learned from my experience or my knowledge, I would feel that people are growing and we should help each other, because I'm also learning. That's the case.
I hope all of them will follow this 4 P's and grow together and have a good succeed. Like they can have a great success and they can grow in this profession very well, like you and way more. Thank you so much, ma'am, for joining and
Thank
busy
you
like
so much,
being in the
Mohan.
high court and all.
Yeah, pleasure is always mine. And I would love to be there with you again. Just let me know anytime when you feel like any good topic which I can cover.
Sure, ma'am. Sure, ma'am. Thank you so much, ma'am.
Thank you so
And
much. So may I leave
thank
the
you,
chat?
ma'am. Yes, ma'am. Sure, ma'am. Thank you so much. And yeah, I would, and I will be giving you the feedback form. Just a minute, guys. Just a minute. 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 Yes, the feedback form is given in the comment section. Do fill the feedback form and let us know how was the session. And yes, do share and subscribe, guys. So show some love to this channel. And yeah, we will be coming with these shows, these webinars, and different outlook as and then. And the next webinar is scheduled on this Saturday on the what is the topic? Various stages of criminal trial. The registration is link is out. Do check that out. Share, subscribe, like, however you can help. to support this channel. And I say goodbye to everyone. Have a good evening and thank you for joining in between week and learning something new.